Good morning, everyone. This is Amy Valdivia with the Divorce Literacy Podcast. And today I am very excited because I have someone who I admire and I have learned from in the few years, just a couple years that I've known her. And I thought, oh my gosh, this lady is just amazing. She's Miss Terri Breer from New Day Divorce Center. Yay!
Hi, Amy.
Miss Terri. She's an entrepreneur, she's an attorney mediator, and she is a trainer. More importantly, she's an educator. And there's a big distinction between those two. And I've watched her and I've observed, boy, this is someone who really understands her craft and how to share that information with all of us. And so I'm so happy to have her here today. Thank you so very much, Miss Terri. I would love to jump right on in this and share everything that you have to give with the world. Tell me, who are you and how did New Day Divorce come about?
Well, I want to start out. I loved in your introduction when you called me an educator, because that is, I think, my role. And I'm an educator because I'm training mediators, but even more so, I'm an educator because I educate my clients about divorce. And so I'm a divorce mediator, divorce attorney, but I'm only working as a mediator now. But a big part of what I do in mediation is educate clients. And actually, New Day Divorce, my tagline is empowering decision making. And so what I'm trying to do is empower my clients by providing them legal information and also by having skills as a conflict resolution professional so that they are empowered by my process that I've set up to move them through the divorce process and stay out of court. So, but the calling me an educator was really, I love that. Thank you.
Very good. Now, okay, you talked about the fact that you're doing everything to stay out of court. Prior to, I mean, you are an attorney, so I presume, yes, you were in court.
So yeah, my early career was as a real estate litigator. And I was actually in court every single day of the week, doing what is called relief from stay in bankruptcy court. The young attorneys in the firm that I joined right out of law school, we all had to do the routine of court appearances, which included one of the main clients in this real estate firm was what we call secured lenders in real estate. So they would have these huge portfolios of residential properties. And it was in the early 80s when it wasn't as bad as 2007, but it was a definite real big crash. A lot of people were losing their homes. And so these lenders who had bought up all these trust deeds on the secondary market they'd default and they'd have to go in. People would file bankruptcy to save their home. And I would go in, get relief from stay, take their home, then turn around and come back later and evict them. And so I didn't last very long at that. It was very depressing. I think I was at that firm a year and a half. And I went on to do some other real estate, but 3 years in, I opened my own practice. I'm just crazy. I don't know. And so I was in my late 20s, and that's when I started kind of my entrepreneurial solo practice as an attorney doing real estate law. And how I ended up in family law was really kind of interesting. It was more just, I was a young woman practicing real estate law in Newport Beach. So you think there's a little competition, you know, the firms and all that. And so a colleague of mine was doing criminal law and family law. And he basically said to me one day, you know, I really just want to do criminal. And you need, because you're a woman and you're young, I think family law would be good because you have more credibility in that field. More women are accepted in that. And, you know, so it's a long time ago. I mean, things have changed. It's not like that as much now, but it was challenging, a young woman with her own firm. So I started doing the family law, and very quickly I realized I didn't like litigating family law. So I was doing that. I'd probably been litigating about 6 years, family law, real estate, and business, when I heard about mediation. And furthermore, I'm a graduate of Pepperdine Law School, and Pepperdine in 1993 had just opened the Straus Institute of Dispute Resolution, which is today one of the leading mediation I mean, you can get a master's in dispute resolution there. And they were the first one. There was Harvard on the East Coast and Pepperdine on the West Coast that was offering mediation. So I went and got trained and I got a certificate. It was called Domestic Dispute Resolution. And then I just started mediating. And it was very challenging then. And this was when you had yellow page ads.
Right.
I added divorce mediation to my yellow page.
Okay.
That's what I started doing.
We know how tough litigation, divorce litigation can be. And it drags everyone through the mud. Oftentimes, it's not fun. Back then, mediation really wasn't the cool word.
Nobody knew what it was.
Right. So,
and the joke was that everyone thought it was meditation.
Yeah.
Like they were always like, meditation, what are you doing? And, you know, there was no yellow page section under mediation.
Right.
You had to be in the legal section and then say, hey, I also offer this. It was really, really new in the 80s.
So what was the draw? What made you think that you wanted to go to meditation instead? I mean, what?
Well, it was really just kind of a natural affinity that I had towards, like, the most enjoyable cases I had in family law was when I had a great attorney on the other side, and we'd all just go into a room and sit down and go, hey, let's figure this out and chat, and it would work out, and the couples were nice to each other, and they weren't really that adversarial. And there were a lot of those times where it just wasn't that adversarial, but that was sort of like hit or miss. And so you never knew who you were going to draw on the other side as the opposing attorney. And if you got the wrong one, it was miserable. You know, they were so formal. They just go through all the hoops. And, you know, I would be like, okay, look, this is pretty simple. Let's just sit down and talk settlement, you know. And I can remember one of the main reasons I stopped litigating was this. And I hope we have time for this scenario, but this happens today all the time. So my client and I would sit down and she would say, Terri, it's really easy. This is what we're going to do. We've been talking about it. I just want this and that and blah, blah, blah. And I go, well, why don't we just write all that up in a proposal and, you know, send and say, hey, here's what, you know, our global proposal is. Let us know what you think and go from there. And I'd fire off a really nice, friendly letter that I think that our clients have been talking, and let's do it. And I get no response. And I get no response. And then they'd file a motion. And in the motion, they'd be asking for this and that and this and that, everything that I was already had offered in a letter. And they do this formal motion. And then I'd be like, oh my God. So then I try and call them about the motion and say, hey, we agree to this. Won't take your call. Won't take your call. So then you got to file a response. And you got to spend your client's money. You file a response. And then you'd walk into court. And the first thing the lawyer would say to you is, let's go down the hall and work this out. And I'd be like, yeah, that's what I've been trying to do for 2 months. But they would take care of their fees. They would make their money because they made more money filing a motion. Well, they don't make any money if they don't file a motion. And I just short circuit it and say, let's get to this settlement. But every now and then you would do that and you'd get a call. God, I love getting your letter. Hey, Terri, let's all meet. How about this? Check your calendar. Let's have a 4-way, and I think we can wrap this up. That would happen for every time there was that ugly response where it's like, so what I started doing was I would walk into a court hearing with the full settlement agreement all written up because I knew that's where we were going to go anyway. You know, and so then I started getting a reputation. I had a bailiff once that used to joke and say, here comes the settler. Or he'd call me the pioneer, the settler. It was my natural deal. And I just didn't have that litigator's heart.
I call it prepared, right? As opposed to settler. You know, you hit the nail on the head. Mediation is a completely different emotional response by all parties.
Well, yes, sometimes you're right. But I usually like to say mindset. because the emotion is not, the same emotions are present. It's the
Understood.
mindset and the management of the emotions, and providing clients with a way to manage it and de-escalate it, rather than you get two people, one that walks into a litigator's door and the other that walks into a mediator's door, and they have the exact same level of emotion, and it's not going to come out that way. The litigator is going to escalate it and create more fear, and the mediator is trained to make sure that we manage that emotion, see the emotion, and manage it. Litigators are more like, well, don't go there, don't get into the emotions, that's not your job, and so mediation, to me, the mindset is what matters, and the mindset is your clients have to have a cooperative mindset. Okay, and that's the key, a cooperative mindset, as opposed to an adversarial, I'm at war, I need to protect myself, and I'm going to fight.
Well, at $400 an hour
or more, or listen, hey, Amy, I'm hearing $800 an hour for some of the leading family law attorneys in LA and Orange County. $800 an hour, that is not unheard of these days. It's high, but it's out there.
Okay, so this brings up a completely different point outside of the divorce arena that we're talking about. We are talking about settling and helping clients, but as an entrepreneur, there's that moment, I gotta believe, where $400, $800 an hour, or the mediation fee.
Well, you definitely make less money if you choose mediation. Okay, and so obviously that wasn't, if I wanted to just make a lot of money, I'd be litigating. That's where the money is for an attorney, but you can make a very nice living mediating, and it's more enjoyable.
Right.
And I also have something unique that I do, is I do a flat fee mediation program that's really popular. And I've been doing that for a long time.
Right. I was going to say, you've been flat fee for years, where flat fee seems to be the new buzzword behind the fact that we're collaborating and we're mediating as the new buzz in the divorce.
Well, you have to, I think, to feel comfortable quoting a flat fee, you need to have, I've been mediating 30 years. So I've been an attorney 35, but I've mediated enough to know, and I do a longer intake. Like when I do my first consultation, my initial consultation before I'm hired, I tell them it's an hour and a half, because I'm going to gather a lot more information so I can quote that flat fee. And so and there are a lot of people, my colleagues, that will say, how do you do that? I mean, what do you do when you haven't quoted enough or whatever? And I'm kind of like, well, some cases, yeah, I make a mistake and I don't make as much. But for every case that I don't make as much, I may quote somebody 4 sessions and they finish in 2 and they're thrilled, and I get the same fee. So it kind of balances it out. And so, so therefore that flat fee arrangement doesn't work for everyone. Some people are not comfortable with that. They want to be paid for every hour, and there's nothing wrong with that. But that just wasn't how I like the flat fee. I get paid all up front. The money is no longer an issue. My clients don't worry about, what is it going to cost? How much is this going to cost? No, you already know. I quoted it and I collected it, and we're done with that. Now let's focus on settlement. The other nice thing about flat fees is I call it the clock watchers. If you know you're being charged hourly, then you're going to be watching the clock instead of focusing on the settlement discussion, because you're worried, it's like, I don't want to get charged another hour. My clients, that's completely removed. So we're just in the moment, working on whatever it takes and not worried about how much it's costing, because they already paid for it. So that's what I like about the flat fee.
What is your average number of sessions that you find that you're
3 to 5?
3 to 5. Okay.
Usually I'd say 4, right in the middle is the average. And the way it works is my first session is information gathering. Okay. And that's also step 1, so to speak, where in California, you have to complete certain disclosure documents. Okay. Those disclosure documents, you can kill 2 birds with 1 stone. The mediator needs to know what this marital pie is. The mediator needs to know, do you have real estate? Do you have retirement? What are your issues? What are your income? And all of that. But guess what? The state of California requires you to list all that stuff. So my first session would be, everybody's going to be coming when they filled out those initial forms. We work on getting that whole inventory done and their income and expense. And then I usually have 2 to 3 negotiating sessions. And then in a 5-step case, the last session they're signing. So it's usually that 3rd or 4th or 5th session is the signing session. So depending on how broad the issues are, how the clients present in terms of, have they been talking? Are they able to talk? Are they only going to talk when they're in a room with me? You know, are they really just the worst mediation client, I think, mindset wise, are those that are there for one reason: they want to save money. And fortunately, that's part of it for everybody. But occasionally you'll get people that it's not about the mindset. They're not trying to be good to each other. They're cheap. And I shouldn't say cheap, because it is expensive to divorce and it's a good idea to try to reduce the costs. But sometimes they're so focused on saving money that maybe they shouldn't even be in mediation because they don't have the mindset. But again, that's the minority, but you do see it.
As the conflict resolution specialist, you're moving them away from that into focus on what they're trying to accomplish.
Well, on problem solving. And the other thing that I do as a mediator that's a little more unique, I always call this, there's this kumbaya umbrella in mediation, and it's wonderful. Okay. And that's all the things about kindness, being respectful. As a mediator, you're trained how to empathize, make sure your clients feel like they're heard. And all of that's very, very important, the kumbaya part. But what really is most, I think, the key to a good divorce mediation, clients have to roll up their sleeves and go to work. They're not spoon-fed in my office. It's like, hey, you need to know what your assets are, and you need to understand the basic legal rules. And I'm going to provide that information for you, whether it's in a handout, whether you can ask questions and I'm going to answer it. But this isn't where you just come to me and go, well, tell us what to do. You know, and a lot of people will come to mediation and they're kind of waiting for me. Okay, Terri, so what do we do now? I'm like, well, it doesn't matter what I think.
Right.
The goal, the two of you have to decide. Or a client will send me an email and say, so Terri, what do you think we should do about this issue? And I'll say, well, I think that you should consider the legal information that I provided and the conversations that you've had. And we'll talk, you're going to, you have to convince your spouse, not me. And there are some clients that's very hard for them to grasp. They're constantly talking to me.
Oh.
They need to talk to each other. That's what matters. And I structure and facilitate their discussion. So a lot of times it's very challenging because clients, they don't know how to make proposals to each other. They don't know how to hear a proposal and respond without freaking out. And I have to say, okay, you don't want to do that. What do you propose?
Right.
Or what's acceptable about that? What isn't? How would you change that proposal to make it acceptable? And you start teaching them those skills early on in the mediation. And that's, again, comes back to my tagline. They become empowered. They're empowered to, oh, Terri got us through that. You know, I've had people say, look, we're mediating, but there's no way we're ever going to agree on support. Okay, well, we'll see. You know, and then they'll go through it and they'll agree on support. And they're like, you know, I never thought that would happen.
Right.
So hopefully that's because I do have mediation skills. I mean, we do bring a skill set. And I say, well, when my clients say that, I'll often say, well, if you had agreed on that, I wouldn't have a job. You know, why do you think there's mediators? If you don't come to mediation with an agreement. The other mistake clients make is that I've had them, like, they hire me, I give them their homework, which is, you know, the inventory, the schedule of asset and debts, the income and expense. I kind of don't hear from them, you know, and I don't hear from them. And then maybe I'll get an email and one says, well, we're working really hard on getting all that together and we haven't figured out what we're doing with the house yet. So we'll let you know when we're ready to come in and tell you what we're doing with the house. And I'll be like, okay, that's why you hire me.
Right.
And I'll sit back and I'll go, that's what we're going to be doing. And, you know, so it's often a big, there's so much education, not just about the law, but about process. And so a lot of times I've even had clients calling in and saying, look, I know you mediate, I can't mediate, but I'd like to at least meet with you, blah, blah, blah. Well, why can't you mediate? Well, we haven't agreed on everything. And you're like, okay.
We're trying to accomplish. Yeah, you know, and that's it. You're bringing up so many wonderful nuggets about the whole mediation process. Number one, your real estate background. That
It helps a lot.
helps. Yes.
Yeah.
And because you can understand. And one of the things where I am involved is oftentimes I hear, oh my gosh, but my kids only know that the Christmas tree goes in front of that window. And I never want to change that. I don't want them to lose their memories just because mom and dad aren't together anymore. And I want them to have that. And there's that emotional tie to the Christmas tree in that window to have the home. And oftentimes I find that attorneys just list it like another asset. So it's so nice to hear you talk about there's much more to it.
Well, what's interesting is I'm glad you mentioned that, because one of the advantages I had throughout my career was a lot of family law attorneys are intimidated by the real estate. I mean, the attorneys get up to speed very quickly, but there's some mediators that are not attorneys that really are uncomfortable with the real estate. So I always felt very comfortable with real estate, and I've been able to do a lot of cases where they own apartment buildings or they've got investment real estate, or they, you know, I mean, well, sometimes it's overwhelming for a mediator if they have a family residence, a rental property, and a vacation home. You know, each piece of real estate, you have to dig in and get and extricate the same information. But, you know, you were tying, though, the real estate to, oh, it's the home, it's the family home. Yes, that's important. But one thing I often remind people is it's usually the parents who are more upset about the house than the kids. They assume that is, and sometimes they're right, but I think a lot of times they are, what's the word? Maybe it's a transference, or their fear of leaving the home. They think the kids must have it too. And I'll tell you a quick story. I love this story. I had a client tell me, the clients were really nervous. I'm moving out. We're moving out. He's going to get his, he's staying in the house. I'm going to the apartment. I'm going to bring the kids to the apartment. I want to meet with the parenting coach first. I don't know how they're going to take it. They're going to walk into the house and it's just going to be so upsetting because they don't have the big house that their dad has. And I said, well, you know, good idea. You can talk to the parenting person. They come back the next week and the wife is, oh my God, Terry, we walked in the house and the first thing my daughter did is run upstairs and go, can I? Yeah. And, you know, and the son goes, well, do I get is this my room? You know, and the kids were off running around the house, running in the backyard. And the mom's standing there going, thought everybody would be upset. And I'm not saying that happens all the time. Right. But, you know, she said that was such a, she realized it was all about her mindset. Right. The kids were fine, you know, but that isn't always the case. But I like that example because those things do happen where they are that resilient, or they see, you know, we often will hear in divorce coaching, divorce is an opportunity. Conflict is an opportunity. Divorce, it may feel like the worst thing that's ever happening in your life, but it ends up being the best thing that ever happened. And those are similar examples. As you have all this anxiety, the worst thing that could ever happen to my children is they're leaving the family home. And all of a sudden it turns out to be the best thing. Guess what? They got more kids around the corner. The school is closer. The school is better. You know, we're happier now that dad and I aren't in the same house. It's so much better now that I have my place and he has his place. So there are silver linings to the sadness, you know. Definitely.
Every divorce is different. Like when we even talk about the mortgage side, every transaction is different. Every home loan is different. It could be a refinance, but those refinances are for 100 different reasons. It could be a purchase. Those purchases are for 100 different reasons. Let's talk about the structure of mediation.
Well, can we for a minute, though, I want to circle back because I know you're interested in real estate. The thing I do want to say that I think you'll enjoy is this. what I just explained is what people worry about. But what they should be worrying about is, can I qualify for a refinance? Can I buy out the other party? What is the budget? And those are issues that get missed when we're worried about kumbaya. The kumbaya is, how do I shelter my kid from this devastation of losing a home? Well, no, that kind of may not be the biggest problem. Your biggest problem may be, did you try to keep the home because of that, and you can't afford it? And it's not in your budget. Oh, and guess what? You can't refinance and ever get your spouse off the loan, and you have no business even staying in the home anyway. So I just wanted to say, because I know that, you know, that's the challenge of getting them to someone like you, Amy, is you want them to have that look-see very early on in the mediation process, so that I'm not trying to negotiate who gets to keep the house when neither of them can. And what a waste of energy if we've done that before they visited you to see if they qualify.
And if there is an opportunity, okay, what is it going to take for that opportunity to occur? So that way they have the true meat to negotiate over. Okay, this is what it's going to take. Maybe I don't really want to go through that, or maybe I do, or maybe, okay, now there's a different solution on the table. Maybe look at a different angle.
Yeah.
Okay, now, because I know another part of when they come to the Terri Breer experience, what they get is truly a trained mediator. And you talk about the structure of mediation. And that's what I want to go back to. When I went through training, I remember giggling, thinking, oh my gosh, placing tables and chairs in a certain way where now I'm facing the individual that I don't want to talk to, or, you know, what's my body language and how far is that human? Because sometimes it's a pretty nasty divorce going on by the time, you know, when they're walking in. Tell me about that. Tell me about how you prepare these people.
Yeah, so I have my own, I call it my mediation room. It's, or my own conference room. I've had a round table for 30 years. Okay, so it's a round table with 3 chairs. And then I always have an extra one in the corner in case we bring in a financial person, or somebody wants to bring their mother or their sister, and they all agree. So I can have up to 4 or 5 around the table, but generally it's just the round table with the 2 clients and me. And that's always set up that way. I think there's enough distance. Sometimes I think I should have a little larger table that maybe we could put more distance, but they're able to like push their chair back if they want to feel more comfortable that way. I also I don't know if the majority of mediators do this, but most of the mediators that do purely family law are usually doing joint sessions. So it's very rare that I have a one-on-one session. Okay. I do some one-on-one phone calls after a session. And I also have some one-on-one emails, but largely everything that's done is together in my mediation room or in an email that may be addressed to one party, but it's always copied on the other party. Okay. And I try to keep most of the negotiation. I like to keep it within the mediation, but I always encourage clients who I can trust not to get in fights outside of mediation to talk outside of the mediation. So a lot of times I come up with 3 or 4 options that they hadn't considered, and they all of a sudden will say, well, we'll talk about that. And I'll always say, well, behave, you know,
right.
As long as you behave, I'll encourage that. There's other people that'll say, please don't do that, because they can't manage it, you know. But most of the clients, if I come up with if we're talking and let's say husband says A and wife says B, what do you think, Terri? You know, and I may say, well, what about C, D, E, or F? What do you know, and then we'll tell us more about that. Well, some couples will do this, or based on what I'm hearing, you might consider this, but I don't say, I think you should do this. Okay. Occasionally I will do that when it's like really, maybe they're about to do something really silly or really overlooking something or creating a tax problem. I may say, whoa, you know, but normally that I don't need to go there. And I let them continue that conversation with each other. And so, but the majority of what happens is I meet with them for 3 to 5 sessions. The first session, what I always love starting with, it makes sense just from a logic sense, but it's also part of, you were talking very early on about the emotions. Well, one of the ways that you can manage emotions as a mediator is to give your clients a task. Well, what is more of a task than filling out a form? Here, let's go over, they fill out a schedule of asset and debts.
Right.
And this gets into your left brain, right brain stuff. Okay. So
Right.
your right brain, your emotions and all that. But if somebody's emoting and getting all upset, put a pencil in their hand or a pen in their hand and go, a list. Oh, okay. What would you like me, make a list of all the reasons why you think the property should be listed for sale,
Right.
rather than emoting, getting all upset. I can't believe you want to take the kids out of school. I can't believe it. Okay, hold on. You can do it that way. And that's why my first session is always that information gathering, because that entire first session, you want to handle non-emotional issues, and you want them to see that they can be successful without getting emotional. I think a lot of mediators make a mistake. They immediately start with parenting. Well, that's the most important. No, it can be. For me, that's the easiest mediated issue, but it's the most fearful and emotionally charged issue for a lot of people. And if you immediately start with, well, let's talk about the children because we know that's the most important thing, you're starting with clients who haven't even experienced a mediation session. You're putting them all in their right side of their brain, of their terror and their fear of, that fight or flight. Oh my God, what am I going to do about my children? Or I'm going to miss them so much. And that's how they start seeing mediation. And they're just not in their best mindset. So I always start the process with very nuts and bolts, and also because you sure can't talk about dividing the pie if you don't know what it is. True. You don't know what it's made of or how many pieces it has. How can we start dividing it?
And so you instantly are diffusing the situation.
Daily. So it's a great, there's just so many benefits to information gathering. You start with that, because not only is that what you need as a mediator to figure out an action plan, if you don't know what all the assets are, how can you say, oh, you're going to need an appraisal there? Or how about the retirement? You're going to have to go back and get that statement on the date of marriage, or we're going to have to talk about that. So my information gathering session, the action item coming out of it is your action plan. Okay, now that we've gone through all these assets and I've gone back over everything you listed, for example, just on the real estate, whenever someone's listed the real estate, I'll go through the whole disclosure, then I'll come back and I'll go, okay, let's talk about the family residence. When did you buy it? How much was the down payment? Have you talked with each other about it? Do you want to list it for sale? What is the plan? Do you have a price that you've agreed to? And you do that for every single piece of real estate that's on that. And you do that first. Right. You don't start talking about parenting and do that for 3 sessions and then turn around and go, well, what do you want to do with the house? Well, doesn't that kind of impact parenting? If we don't know who's staying where, or where you're living, or where you're moving. Right. So it makes sense. So I do property first in that first session. And then after we've done that, I send them their disclosures on email. And then we set up the second meeting. And if they're going to be gathering more information, like they're getting an appraisal, we'll wait till we have the appraisal before we meet again. Okay. If there's an emergency issue going on, well, then we're not going to wait for appraisals if we've got immediate parenting issues. Or sometimes what happens is they come in for their first session and they're living together, but mom or dad's moving out in a month. Right. Well, then I got to go out of my favorite order and start talking about, well, where are you going? Right. Do you know where you're going?
Make the decisions quicker.
Yeah.
Right?
Yeah. And so it's not like I have a lot of flexibility, but usually my order is this: the information gathering, marital property, parenting, and support. And believe it or not, that's exactly how the family law code is organized. Okay. It's property first, children issues, and support. And that's how the numbering is in the code. And that's because it makes sense. So first, who's going to get what? Because that impacts where children live. It impacts how much it costs, what your needs are, and where your children live will impact what your support is. So that's kind of the flow: property, parenting, support. So
It
that's the order.
so much calmer when you look at it from that perspective. I've never heard someone say it that way, but it's absolutely
Well,
true.
and the other part of that is that's all divorce is. It's 3 issues: dividing property, parenting children, and support. And everything falls under those 3 categories. And it's the same every single divorce. Nobody has any other issues.
Right,
Now, there's
right.
a lot of variety under those issues. And, you know, taxes is kind of a hybrid. Taxes is a property issue because it's a debt, right? Or,
Right.
yeah, but
Yeah,
it's also a support issue. Okay, so it falls under those categories, but you can't name anything that's an issue in divorce that isn't going to land under one of those categories, you know, in terms of what you legally have to agree to. Now, I also believe that there are at least 7 levels of separation in divorce. So there's the legal divorce, the financial divorce, the physical separation. It's actually separation. So, you know, legal separation, physical separation, social impact separation, parenting, you're separated from children, your emotions are another transition, you know, but there's all these things that are going on in addition to those other things. So I'm not saying all of those are covered in 3 categories.
Right.
But what has to be determined to get a judgment is only those 3 areas. In other words, I don't have to solve who's going to visit what friends in the future. I don't have to rearrange your social arrangements. That's definitely out there. You're probably going to have some friends that go with one or the other. I ain't mediating that. I'm hired to get a judgment entered, and I have to cover property, parenting, and support. And so that's another thing that I think some mediators will make a mistake is I'm not saying that your emotional health or the social issues aren't important.
Right.
But they are, I believe that you have to get the judgment you have to get the divorce, then turn to recovery. But people that are trying to use the divorce process to recover from the divorce, you can't, it makes it more challenging. You're trying to get a grand slam, you know, get a base hit, and then we'll worry, but you know, get your settlement in place, then fix your emotions. And hopefully that process of getting that divorce in place doesn't damage your children or hurt you more emotionally. And I'm saying it's all important. And some people, it becomes more important to focus on those issues, but that's only 10 or 20% of my clients. The majority of my clients, exactly how I lay it out, works for them. But there are those clients where I immediately have to send them to therapy or
that's just it.
Or a coach.
Right. There is a specific flow, a general flow to a divorce. And some people need just a little bit of extra coaching or, you know, therapy or.
And they can get that.
Absolutely.
But to put that in the mediator's hands on top of all the other things that the mediator has to do. Now, I like to think I have a certain skill of the conflict resolution, and I know I can help with the emotions, and I've taken a lot of courses, and I often feel like a psychologist in the mediation. So I'm not saying, nope, we're not going there, it's all about this and that. But what I'm saying is you can't lose sight of what I call the core proceedings. And the core proceedings are, this couple's got to get started, they've got to file they've got to have legal paperwork, and they have to have a settlement. And they're not, you haven't done your job if you don't get them through that whole linear process.
This is what you're paying me for. This is what we're going to work on. This brings up a fantastic segue to the Attorney Therapist Breakfast.
Yay.
That's who you have created this networking event for and with in order to partner those individuals. Tell me a little bit about
Well, here's how it got started. In the 90s, there was a group called the Attorney Therapist Network. And it was litigators and what are called your 730 evaluators. So when you do not settle custody in mediation and you go to court, if it's a highly contested custody issue, the judge isn't going to figure out what's best for the children. They will assign an expert to do a custody evaluation. under Evidence Code Section 730. So the lingo, when you hear 730 eval,
Right.
you know, someone will say, well, how's your custody going? Oh, we're still waiting for the 730. You'll hear that expression. What that refers to is a therapist, marriage and family therapist, psychologist, psychiatrist, even somebody's going to come and evaluate, do a whole recommendation for the judge. So the judge can figure out what's in the best interest of the child, because a judge can't figure that out just by talking to the, you know, so they send out, you know, they'll meet. So they do that whole process. So the Attorney Therapist Network was started for 730 evaluators to connect with litigators. And they were more like just sharing how to read our reports, how to do this and that. And then there was also just the synergy and the networking of therapists referring and attorneys and so forth. Well, I don't know what happened to it, but all of a sudden it just was no more. And so I network a lot. And one day I was out to lunch with a therapist, and she turned to me and she goes, Terri, whatever happened to the Attorney Therapist Network? I go, you know what? Yeah, what happened? I go, yeah. And she said, you know, that would be a great thing to do again. I go, yeah, you know what? It really would. But I didn't want to focus on the litigation aspect, right? Because that Attorney Therapist Network. So I sent out an email to a bunch of colleagues and said, I'd like to have a focus group on whether or not you'd like to start a new Attorney Therapist Network. So I held like 2 meetings. I had almost 20 people at each meeting, and everybody wanted to have a group. And they all wanted to do it like at lunch or in the evening. And I wanted a breakfast meeting because I had a lot of lunches and dinners with other groups. So I thought, well, I'm going to call it the Attorney Therapist Breakfast Club. That solves it. And I'm the one laying it out. So it's in the morning. I guess it's a breakfast club. And so that was in 2016. So we started that in 2016. And then I did it for about 3 years. And I met at Mimi's Cafe in Lake Forest until COVID. Then COVID came along and I did 2 online ones. And I said, no, it's not the same. I want to have a breakfast meeting. So didn't do it for about 1.5 years. Then once COVID was loosening up, or all the restrictions related to that were loosening up, I call up the Lake Forest Mimi's and I say, I'd like to start all over again. And they're no answer, recording, they're out of business. Oh. So I then moved it where it is today, and where I met you, I think, was at the Tustin Mimi's Cafe for the Attorney Therapist Breakfast Meeting. And we meet the 3rd Wednesday of every month. And I mean, you can talk about that a little bit. What has that been like for you? I love it.
That's, for me, you know, obviously everybody's there to share about their business and get to know like-minded individuals in the same arena. For me, it's so welcoming. Everyone wants to know, who are you and how can we all help? How can we all fit our puzzle pieces together to make a divorce much like what you talk about?
And let me just add this. So the network, I dropped network too, so that it wouldn't be associated with that. But because of who I am and my background, that's how the meeting sort of segued into divorce. But I was really just saying any attorney, any mediator, any therapist from any field. And we do have some business attorneys, we have probate. And so I like that, but it's largely, like you said, it's mostly divorce professionals who are looking to collaborate. It's expanded. We do have some financial and real estate people that come, but I really don't reach out to just anybody who does real estate. It's somebody that is interested in collaborating with the divorce professionals who attend those meetings. Or, you know, it's sometimes your real estate and financial also mix well with, have a couple of probate attorneys that regularly attend. Or you have some therapists that focus on elder issues. So it's a little broader than just divorce, but definitely I would say that is the main focus.
Even though it is broader than divorce, there's always a common thread. I was at a estate planning succession meeting, and one of the things we talked about as they were asking me questions about divorce is, oh my gosh, you're doing the same exact thing in divorce that you do in trust. I said, yeah, It's
Yeah.
the same thing. So we have the common thread. And by the way, there's this emotion and there's all the mindset, using your word, in both situations, because you have family members fighting each other.
Well, yeah, and the
Yep.
other connecting thread is there's a special relationship.
Mhm.
So, and you know, I've often, I did a workshop many years ago on mediating special relationships. Well, what does that mean? Well, certainly divorce,
Right?
probate is family members, succession, or friends, or
Yes.
what, you know, or people that are important to each other,
Yes.
and employment, HOA, neighborhood disputes. And so what I really think the focus of that networking is professionals who are involved in special relationships, in helping manage special relationships, more so than, you know, and that's the umbrella that embraces all of those familial things. And that's the same reason why you'll have realtors and lenders there, because probate and families, there's these special relationships. They don't want to just go to court and order a house sold. They want to look at ways of handling a buyout where it's amicable and cooperative. Because guess what? There's a special relationship that's going to continue. My child, my sister, you know, my brother, my mother, my dad, you know, so those make the difference.
Well, with 35 years practicing, tell me, what's that one case, the special relationship that just always you always carry with you?
You know, I know you mentioned that you maybe want to ask about that. And I will say this, it's not like I have this one case. It's not like, oh my God, that was the one. But this is, I see this, it's kind of, occasionally this will happen. I have a very high settlement rate, 90 to 95%.
Beautiful.
But that means that 1 or 2 a year, for whatever reason, aren't getting through the settlement at the end. And I hate that. I just really, I don't want them to get away, right? And so this happened just recently. I had a couple that came in 2019, the end of 2019. And I worked with them, rolled into 2020. We were 6 months in. I had the final agreement done. We were going back and forth. And all of a sudden, something blew up outside of what we were doing. So I had this final agreement ready to go, all ready to sign. And I get the call, Terry, we're terminating the mediation. Sorry, it just isn't going to work. We're, you know, blah, blah. And I was like, and I just, you know, I reached out a little bit and said, well, you know, no, she's hired a lawyer. I'm hiring a lawyer. And thank you so much. We really appreciate everything you do. So 2-3 years go by and I don't hear from them, and I've closed the file, and I get an email. Hi, Terry. We'd like to mediate with you again.
Oh.
And this was 2023, you know, about February or March. And this couple that was one of mine I didn't get, you know, and they come in and I find out that all they've been doing is fighting for 2 years.
Oh.
That they never did really get the lawyers to do anything. Nothing has happened since they left me. And they came back in, and with the passage of time, and that's what I want to say is, what I think is interesting as just a memorable case, it's memorable cases are ones that make you realize that sometimes all they really do need is passage of time. And, you know, I never push the pace. I always tell my clients it's your pace. But what I've had is on a number of occasions where I had that, darn it, that was my 1 or 2 this year that isn't settling. I've had a lot of those come back a couple of years later.
Wow.
And sometimes it was really good that they took that break. They weren't ready. They were not ready to do it for whatever reason. Maybe they were bargaining. Should we divorce? Shouldn't we divorce? They just weren't there. And I didn't have to do anything but let them go. And then they came back and it was like, okay. And you know, and they just boom, 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 and they're done. Those, to me, those are the cases that are the absolute most rewarding, because they went from being my biggest defeats to my best successes. Because I think if you can get somebody after a 4-year divorce or a 3-year divorce, if you can clean it up and get them to move on with their lives and get it settled, that's, to me, the most memorable cases.
What a beautiful testimonial to your practice. And definitely, all I kept hearing in my mind was time heals wounds, right?
But again, that you'd like to think that's always the case. Sometimes that's a problem, like they fester, but normally my experience is that a lot of them that had to go away, they just needed that time.
Yeah.
They needed that space. So I'm always telling my clients, I'm never going to call you up and say, hey, I haven't seen you in a while. Hurry up and get in here. I got to get you divorced. No, I only move the case forward if one or both of them is moving it forward. That's my ethical feeling. Is ethically, it's not my job to hurry up and get you divorced. It's my job to provide a process to facilitate it, and you determine your own timing, how quickly you're going to go.
Those 3, 4, 5 sessions could take a few months.
Yeah, and a lot of couples, I've had couples where they come in, they do the first session, they get their summons and petition filed, and they're like, okay, all right, we'll wait. And they come back 6, 7 months later. Okay, we're ready to schedule our first session.
Right.
But I don't during that 6 months constantly write them and go, when are you scheduling your session? When are you? They will let me know if they want to move forward. And if they're not matched, like sometimes there's the leave-or and the leavee. So somebody may be in a big hurry to move forward and the other isn't. But as long as at least one party is moving forward, then I will move forward. But I am not going to, jumpstart any divorce process. They have to move it themselves.
Well, you just sold yourself. If anybody needs somebody to mediate a divorce, or I mean, obviously that's your focus, but if they see that that's where they're going, they definitely need somebody with your tenure and just your compassion for everybody. And it's amazing. And more importantly, let's talk about the business part. You're based in Southern California.
I'm in Irvine Spectrum.
Okay.
And I prefer the old-fashioned way. I'm still doing a lot of in-person. Clients come into my office. They do not have to. I do the initial consultation, both in person and on Zoom. And then it's up to the clients. Some of them will do all Zoom, all in person. Some mix it up. Sometimes I'll have one party be in the office and the other party join us on Zoom. But if I had my way, I don't have a round table for no reason. I want my clients sitting at that round table with me in the mediation room. And that is definitely changing, but that's still a big part of my practice is still that way. And that used to be the only way, but definitely there's a lot of options now.
What I found with multiple individuals recently, it seems like they're leaving the state. So I asked that question because how do you feel about those where maybe you have somebody here and somebody?
Well, then I like Zoom because otherwise I wouldn't get the client.
Right.
So, I mean, and I do have that's the number one reason that I do embrace Zoom, but I don't like it when someone says, I just can't handle being in the same room with them. And they got 3 little kids. And you're kind of like, well, we're going to work on that because that is just, I don't let you get away with that. Now, sometimes you have to. I mean, if they're extreme, but it's like part of what I feel as a mediator is I want them to understand that they can, be mature. Right. You're not a child, and I often will say it's, big girl pants, big boy pants. That, it's not time to say, I can't handle it. I can't handle it. Well, yeah, you can, and again, there are exceptions, but I really, for a large part, I just don't buy that. I think that, you should be able to manage with a mediator. Now I get it, maybe if I'm not there, but that's what I'm trained to do. And then if they at least give it a try before, I don't just let them say, I've had well, there's no way I'm ever going to meet in the same room with them and I'm stuck with that. But I usually will encourage, can we at least try, for a joint session or some of them won't even meet jointly on Zoom. And that's just not my style.
It's amazing to me. Well, if people are interested in talking to you or maybe learning more about how you can help them, how can they find you? Where do they find you?
Well, breerlaw.com.
Okay.
And also I'm going to be rolling out, well, right now, newdaydivorce.com is where I list all my mediation training. But either one of those URLs will get you plenty of information about me.
before I let you go, this training piece, that was something that we talked about early on, and I want you to talk a little bit about your mediation training for this reason. Trainers just give a bunch of information and they talk at you. You truly educate those individuals coming to your trainings to be mediators themselves.
Well, interesting point. So, earlier I was saying there's the kumbaya mediation, and then there's the property, this and that. There are a lot of 40-hour mediation training programs. They're very popular and they're excellent, but they are not providing, say, California divorce law, or, how do we handle real estate under the family law code? What they're doing is they're teaching the kumbaya skills. This is how you resolve conflict. This is how you structure a mediation session. This is how you can empathize with clients. And they teach mediation skills. And my training is not a 40-hour training. Most of the people you don't have to take the 40-hour training before you take mine. You need both, I think. And so my training is focused on raising the bar or the standard of care of divorce mediators in California. And in particular, I want divorce mediators to know about real estate, retirement, stock options, support issues, and how the minimum that you need to what I call handle a garden variety divorce. And because anyone in the whole world can be a mediator in California just because they say they are, and that shocks people. What do you mean? You don't have to be a lawyer. There is no licensing in the state of California. Anybody who decides to be a mediator can call themselves a mediator. And so I'm worried about that, because just having the 40-hour training, you may say, well, I'm certified in mediation. I took a 40-hour training. But if you don't understand the real estate principles in family law, if you don't understand what Moore Marsden means, or 2640 reimbursement, or if you don't know the difference between RSUs and stock options and what a quadro is, if you don't need those things and you're out you don't know those things and you're out mediating, I don't care how well-intentioned you are or how good you are at resolving conflict, you are not at the standard of care that I like to see in my profession. And so that's where I'm teaching, is that I try to make sure that I have given them the armor of the legal information that they need at a minimum to confidently handle cases, and also that they recognize, the trainees that I'm training, they recognize when a case is not within their wheelhouse or it's outside of their specialty or skill. And so that's the other important thing. You don't have to accept every mediation case that walks in the door if you're not competent to handle it. But on the other hand, I don't think that only attorneys can mediate, or that if you don't have an attorney, you're in trouble. Yes, some cases that's true. But the garden variety divorce, I think that there are just certain basics that if somebody owns a family residence, they're driving vehicles, and they have 2 bank accounts and some retirement. If you learn a certain amount, and that's what I'm teaching, I give them that legal information, then I think that then you are competent to start mediating family law divorce in California, but not just get a 40-hour mediation thing and be ready to go. So if you're looking to hire a mediator, you want somebody that has a lot of experience, and even more experience if they're not an attorney. Just because then you want to make sure they have the understanding of not just how to resolve disputes, but what they need to cover under family law so that everybody is aware of their rights and they don't do something that's going to cause a tax problem or omit an asset or create an unfairness. And so that's what I'm teaching is, my courses are things like the marital balance sheet, dividing real estate, retirement, and stock options. I have a 5-step process for mediation. So my trainings are all geared, whatever training you take is going to include California family law and procedures and case law and standard software and things that a California divorce mediator must have.
Right. Words of wisdoms and the background knowledge from Dr. Terri Breer of the divorce. My goodness gracious, this was amazing and just jam-packed with all sorts of information.
Okay, good. I'm glad
I
you
am
thought so.
so grateful for your time. This is just going to be awesome. And I'm so excited. When it's posted, I will definitely let you know, because this is information that so many people, especially in our Southern California area,
Well,
need.
thank you. I love sharing it. And let's keep educating people.
Absolutely. Thank you so very much.
All right, thank you.